This morning, the concerned citizens of Kano arranged a peaceful prayer session in the Mahaha field. Unfortunately, after the peaceful session, the Nigerian police come and open fire on us. This is open day robbery. The Kano mandate has been stolen by the APC. The APC are trying to turn the Nigerian political system into one-party system. This will never be accepted, and we are calling on the masses to start bringing us food, water, and other supplies. We will not leave this place. We are going to die here. We are going to sleep here. We will not move. We will keep staying here until the justice prevails. Our appeal has been already submitted to the Supreme Court, and these people are calling numerously on the issues to defend APC. APC is a fraud. APC is a one-party system. We are here to die for Abba. Abba is the governor we elected. We are here to die. It's either police to kill us or go and kill Ganduje. Ganduje is the culprit behind all this, what is happening in Kanu. Enough is enough. We cannot continue this way. Enough is enough.
Oh,你们是我落help吗？也是。哎，我落help，说真，俺有过来你是，你我嘛包不赢。
Let me get your initial reaction when you heard about the CTC, and I see some of your tweets about this conversation. I felt I'd like to invite you, and thank you so much for accepting to speak on this matter. What comes to mind when you heard and saw what happened?
What do you mean by what comes to mind? Good evening, Sharon, and the colleague in studio. Thank you for having me. Sorry, I couldn't hear you to begin with because the way technology works. But I'm not quite sure what comes to mind. My mind is very clean and very clear.
So give us an understanding of what you make. If what was read in open court on Friday is different from what we now see in the certified true copy of the Kano governorship election appeal court judgment, what do you think has gone wrong?
Look, my brother, listen. This is the Nigerian judiciary. Anything is possible, isn't it? That's exactly what we see these days. I'm not one of those people who come to your studio and tell you that everything is hunky-dory with the judiciary, and the fact of the matter is that there is now ample material on the basis of which to suspect that judgment, something wrong certainly did happen. And you see, every judgment has three parts, okay? There is the recital of what was filed, what's in dispute, framing the issues. Then you have the discursive part, the discursive dimension of the judgment, in which the judges, the judge as the case may be, discusses applicable law, analyzes applicable law, applies them to the issues framed, and makes their decides how they are inclined. And then you have the dispositive parts. The dispositive parts is actually will be where the judge actually says, this is how I decide, these are my findings, these are my orders, and that's the end of the matter. Now, you cannot say that the dispositive part of a judgment is an error. No judge makes an error with their dispositions and still calls that a judgment. Again, we all learn every day, and I'm learning on your program this evening, that what is said in court is really the judgment of the court and not what is in the records. That's the way law works in Nigeria. You learn every day, and in this studio this evening we are learning. I'm also learning on this particular program that you can appeal against concurring judgments. But you see, that's why I always tell you I'm not a lawyer. I come to this program as an ordinary citizen, okay? And I speak as an ordinary citizen. It's absolute new law to me that you can appeal against concurring judgments. It's new law to me that what the judge says in court is what the judgment is and not what is in the records. Everything I'm hearing here is very new.
Now, could there be, humanly speaking, Prof, and I'd like to ask this innocently on behalf of those who sat on the bench, could this be a clerical error, though?
Absolutely no. There is nothing, you see, there is a doctrine in law, actually, that applies to clerical errors in judgments. It's called the slip rule, okay? So, for instance, if you want to write Wi-Fi and you write wife, that can be corrected. That's a clerical error. That you can, so you can, with consent of the parties, of course, having notified them, revert Wi-Fi, wife to Wi-Fi, all right? But you cannot, with consent of anyone, say that having awarded costs to me, you will cancel that and then award costs to the other party. Or having set aside the judgment of the lower court on record, you then come back and say that is an error. I would actually uphold the judgment of the lower court, because those are dispositive. Those are the dispositions of the court. Once you do that, that's final. The only way you can reopen that matter is upstairs, if there is still an opportunity, or a review, if you're before the final court. That is not a clerical error. That was the old law that I was taught. In this studio now, there is new law coming forth, and I've got to adjust to that. But if you're asking me about the old law that I was taught when I was still a lawyer, no, it's not a clerical error.
So in the 67th page, President Kanu, the Honorable Justice More Adumain has said that I will conclude by stating that the live issues in this appeal are hereby resolved in favor of the respondent and against the appellant. The next paragraph to it says, in the circumstances, I resolve all the issues in favor of the appellant and against the first respondent. He went therefore to say, therefore, I find no merit in this appeal, which is liable to be and is hereby dismissed. I mean, another paragraph, two paragraphs preceding that are different.
Continue to the next line after that, please.
It now says the judgment of the tribunal in petition number PTKN Gov 01-2023 between All Progressives Congress APC versus Independent National Electoral Commission and two orders delivered on the 20th day of September 2023 is hereby set aside.
And the line after that,
the sum of 1 million naira is hereby awarded as cost in favor of the appellant and against the first respondent.
How can those be clerical? So what kind of magic? You see, the thing I don't understand is, I'm not from Kano, okay? I'm not interested in any of the parties in Kano. I am, however, interested with every fiber I have in the credibility of the judicial system in Nigeria. And by the way, the judge who gave this thing is the guy who is being purported or put forward to go to the Supreme Court on the basis of the nominations that have just come out of the Federal Judicial Service Commission, right? So it's a coincidence, I presume, that contemporaneously with this scandal of a judgment, and I'm not going to mince any words about it because I'm not APC, I'm not PDP, I'm QED, I'm not QED, I'm not Labour Party, I'm not NNPP, okay? So let's get this right. On the basis of this scandal of a judgment, that person who wrote that thing is being put forward to go to the Court of Appeal. And the judge who was on reserve the last time appointments were made from the Niger Delta, from the South in 2020, is stepped down in favor of this scandal of a judgment. I think people have a right. Indignation is dead in the country. We're no longer serious about upholding the integrity of the judicial system, of judges, because any judge who puts this thing forward should be going before the disciplinary process so that they can explain themselves as to how you provide a judgment to all sides in the matter. It is inconceivable. It is a bloody scandal. And I'm actually scandalized that any lawyer, irrespective of the side they take in the case, cannot see that this scandalizes the judicial system.
And you tweeted today, you said, you were quoted rather to say Nigerian judiciary is crooked. Did you mean it, so, or they misquoted you or misquoted?
I was not misquoted. I absolutely said so, and I own it with my full chest.
But wouldn't that be a white brush to paint the entire judiciary black?
Look, I said, let me repeat myself. I said so, and I claim it with my full chest.
Even with the consequences that may thereafter abound.
Let me repeat myself. I said so.
What makes you think or say, believe so?
It's not a belief. No judiciary that is credible will produce this kind of judgment and certify it. And this is not coming from a customary court. It's not coming from an area court. It's not coming from a magistrate's court. It's not even coming from a high court. It's not coming from a customary court of appeal, nor a Sharia court of appeal. This is the Court of Appeal of Nigeria, the second highest court in the country. Any lawyer worth their onions should be scandalized by it, irrespective of whatever side you take. Because the country relies on credible adjudication in order to make progress, in order to sanitize society, in order to retain balance in our country. All right? Now, if we are producing judgments like this, and then asking the lawyers to come back so that they can be tipexed and corrected, how do you trust the judicial system? That is crookery. If a judge gives a disposition and comes to change it, and you're telling me not to say that they are crooked, you are not serious. It is crooked. And we've got to say so.
How dangerous do you think, crooked, crooked. It's been a while I heard the word crooked. It was from Donald Trump that I heard it last. If you say our judiciary is crooked, how dangerous could that be for our society?
I've just told you how dangerous it is for the society. But let me ask you as a citizen, would you trust a judiciary at the highest levels in which a judge produces this kind of judgment? Let me ask you, Sheon, would you?
Sitting here on this chair, I just feel like a journalist. Maybe when I step out of this chair, maybe I can think like a citizen. But then, Prof,
let me speak to you like a citizen, because I'm not speaking here like a lawyer. It is crooked. It is absolutely crooked and shamelessly so. We should all be ashamed of a judiciary that produces this kind of judgment. And we should all be ashamed that we are sitting down here talking about changing a judgment that has already been published and certified. And we should all be ashamed that we are sitting down in a television studio claiming that what was said in court is superior to what is certified by the court. That all of this is very shameful. I am really ashamed as a person who used to be a Nigerian lawyer.
Oh, you've since been a Nigerian lawyer? I was hoping to hire you at some point. Would you turn down?
Nigerian law left me a long time ago, because quite honestly, it is impossible to try to advise anybody on the basis of what is happening in our courts. And look, I'm not saying, don't take my word about the crookery. The ICPC published a report saying that lawyers and judges were bribing one another to the tune of billions of naira. This was just 2020. Now, if you looked at what is happening, the numbers would be more than that. And so these are not my sentiments, all right? There is official reporting from official literature from institutions of the Nigerian state. And we're having situations in which judges who were charged, and senior advocates of Nigeria, by the way, so this is not just about judges, who were charged with serious crimes of corruption, have been let loose and let go without being acquitted and returned to the bench. And you're telling me not to say that it is crooked. What is it?
Right. There seems to be some stories about what is happening where the Chief Registrar of the Court of Appeal, Mr. Umar Bangari, has cleared the air on the controversy surrounding the judgment.
It is not his place to do so. The Chief Registrar did not sit on the proceedings, did he?
I mean, let me read to you what he said, Prof, for the benefit of our viewers. He says that, Bangari says that what happened in the judgment body was a typo error that did not in any way invalidate or change the findings and conclusion of the court. The Chief Registrar assures that the error will be rectified once parties in the matter file formal application to that effect. He cited Order 23, Rule 4 of the Court of Appeal Handbook, which empowers the court to correct any clerical error once detected by the court or any of the parties in the matter. He insists that, contrary to insinuation, that the judgment of the court remains valid. There have been an uproar and series of interpretations into the judgment, which upheld the judgment of Kano State Governorship Election Petition Tribunal that invalidated the election of Kabir Yusuf of the NNPP as winner of the March 18 governorship election. Basically, the Chief Registrar of the Court of Appeal, Umar Bangari, is saying that it was a clerical error, it was a typo error, and will be corrected. Prof.
Whatever his name is, Baigari or Mangari or Mangala, is not my business. With all due respect to him, the Chief Registrar, I love him very much, but it is not his business anymore. Chief Registrars don't sit as judges. It's not the business of the Chief Registrar to get in at this point. His job is over, okay? And I described the rule. It's called the slip rule, the reference he makes to the handbook of the Court of Appeal. The slip rule is not available to correct the final dispositions of a court. It is for typographical errors. A final disposition of a court is not a typographical error. That is the meat of the judgment. That's the point here. And as I said, last night, I got several calls telling me that the registry at the Court of Appeal was asking the lawyers to return the certified true copies. How do you return a certified true copy to correct a judgment? And you're not correcting a typographical error, you're correcting the dispositions, the published dispositions of the court. That is a scandal, and that is crookery.
So, I mean, where does this leave the parties in the matter? And I was asking Professor Kano earlier that once this has been filed procedurally in the legal system, where does this leave any of the party? If the judge says it was an error, bring it back, let me correct it. As soon as it's filed at the Supreme Court, what do you think is a norm, or what is procedurally acceptable, or what do you think is law?
That's not my province. I'm here as a citizen. The council representing Governor Abba Yusuf of Kano State is a former chair of the body of benchers, became senior advocate in 1991. So I cannot be giving them lectures as to what to do. I'm sure that they can take care of themselves. I'm not a party to the proceedings on either side.
Let's take a breather. Prof, stay with me. Professor Kano, please stay around. We'll take a breather, and when we return, we'll conclude the conversation on this Kano matter. We'll be right back, everyone. Thank you so much, everyone, for staying with us. Professor Abdulkarim Kano, who is a national legal advisor of the APC, has been speaking with us, and we're getting some perspectives on the state of the Nigerian judiciary from Professor Chidi Odinkalu. And we're learning what is happening in respect of the Kano governorship election judgment and the CTC copy that have now been released out. The Chief Registrar said it was an error. But where do we go from here, Professor Odinkalu, if I may bring you back into the conversation? In all of this, you are being very critical of what you fear about the state of our judiciary in a manner you just described the judiciary as crooked. Well, how do we fix this? I mean, you went further in some of your social media posting to say, look, someone carrying dagger in the open and all that, and you have described how dire and how dangerous it could be for our society. But in your own view, where do we go from here?
By the way, those lines about a corrupt judge being more dangerous than a man carrying a dagger were not mine. They're the words of a former Supreme Court Justice, Samson Odewinge Uwaifo. He's still alive, so I didn't make those words up. You see, I've been at this matter for at least 25 years, right? And in that period, we've also had lots of issues. And we've never had it this bad. We've never had it close to this bad. There have been moments, and look, in the first 5 years, between 1999 and 2004, the NJC disciplined over 20 judges for corruption in relation to election matters. In 2005, the NJC fired 2 justices of appeal over collection of money and buildings in a senatorial case. Now, so let's not behave as if we don't understand that these things are happening. It is the impunity and the complicity between political actors and judicial actors on the scale that is happening that is dangerous. I don't want to focus on one particular case. What I need us to understand is that there is a trend. We need to all act collectively to redress. And when senior lawyers and law teachers come to places like this because of short-term associations with particular political parties and minimize the danger, that, for me, is disappointing. I do think we need to begin by acknowledging that there is a problem. We need to try and work together for the benefit of all sides to fix it.
I think the level that is not the decision.
Are we your slaves? The way you were elected was the way you were elected. Are we your slaves? How else you can suspend me here? Are we your slaves? Every time you keep on picking leadership for us. We are not your slaves. Whether you like it or not, the way you are elected was the way we are elected. We are not your slaves. The way you are elected was the way we were elected. How else you can suspend me? You have done your worst, Mr. President. What do you mean by that? You have done your worst. You have done your worst. You have put us to the wall. Thank you. Yes, we'll start with that. Meaning what? Meaning what? Meaning what? Meaning what? It's unfair. It's unfair. It's not about me, not about any person. It's about the institution of Senate. Thank you, sir. Meaning what? Every time you give it tomorrow, they want to contest election. They want to win us. He's looking at us. So I told you that they will run the court. He brings over the police part of the law. Give a couple, give a couple. He's not that easy. Give a couple to. Not about level. Give him. Let's go see him. Let's go see him. Yeah. Oh. Everyone. Everyone. Come. Everyone. Lead us. Let's go. Yeah.
Leader of the Senate, I would have loved to confer with you, but no problem. The Senate is in receipt of 2 documents signed by the Minority Caucus of the Senate. And I've seen about 41 signatories here saying that they have a temporary replacement for the minority leader of the Senate. And this is a resolution of the minorities in favor of Senator Abamoro. And having seen that he has about 41 signatories to his credit as minority leader of the Senate, I therefore have the privilege to announce that the distinguished Senator Abamoro be moved forward as a minority leader of the Senate. Distinguished colleagues, I also have another document signed by the minority leaders, of whom about 30 of them have also signed, nominating Senator Ositangu as the Senate Minority Whip. Therefore, it's my privilege to announce that they have a temporary replacement of Senator Ositangu as the Senate Minority Whip. Will it so please? Distinguished Senator Ositangu, please take your seat as the Minority Whip. What? Other what?
Slaves. The way you elected was the way you were elected. Are we your slaves? How else you can suspend me here? Are we your slaves? Every time you keep on picking leadership for us. We are not your slaves. Whether you like it or not, the way you elected was the way we elected. We are not your slaves. The way you elected was the way we elected. How else you can suspend me? You have done your worst, Mr. President. What do you mean by that? You have done your worst. You have done your worst. You have put us to the wall. Thank you. Yes, we'll start with that. Meaning what? Meaning what? Meaning what? Meaning what? It's unfair. It's unfair. It's not about me, it's not about any person. It's about the institution of Senate. Thank you, sir. Meaning what? Every time people feel it, tomorrow they want to contest election. They want to open up. He's putting it up. God told you that they will run the course. He brings somebody to his part of the law. Give a couple, give a couple. He's not like this. Give a couple to. Not about them. Listen. Let's go see him. Let's go see him. Yeah. Help them one. Help them one. Come. Help them one. Lead us. Let's go. Yeah. So, let's go. He was taking from God. He was waiting for you. You were looking for
Distinguished colleagues, the Senate will always listen to opinions of members and our colleagues. We will always be sensitive to it. At the same time, next time you bring anything to us to announce, make sure that you have put your house in order. Make sure you have put your house in order. the Senate President can only work with evidence before him. In my front, if you have Abga, a very distinguished Senator Abaribe, very ranked in everywhere. His name is not here. You have Senator Alero, a very distinguished and ranked senator. His name is not here. You have even the former Speaker of the House of Representatives, distinguished Senator Tambua. His name is not here. But I've been given 2 papers. We have distinguished Senator Dixon. We have distinguished Senator Lau. We have distinguished Senator Kwashiki. Even though he's of the SDP, his name is not here. We also have distinguished Senator we have distinguished Senator Jaribe, a ranking senator. His name is not here. But taking cognizance of the number of senators in the minority caucus, you need to know that all you need to produce a leader is majority. If you are like 48 or 49 and 30 people have signed for one person, what is the magic that you say that it should not be announced? If you are like 48 or 49 and 41 people have signed for Abamoro, what is the reason why you say the Senate President should not announce? It's not everybody that will agree, but majority have agreed. And the 2 papers are before me. Please let me finish now. Let me finish. The senior senator, is that Maidugi? Is that Maidugi? No, I didn't call you. I just wanted to recognize you. So I don't. Senator Warada. Senator Warada. I didn't call you, but I wanted to recognize you. Senator Williams, I wanted to recognize you. So I will listen to points of other, but I want you to bear something in mind. In my front, I have 2 papers. Majority of the senators, I believe some are still signing, because not all of you have signed for Senator Abamoro, but he already has the majority. It will be unfair for me to ignore the majority signatures and not announce him as your minority whip for now. At the same time, a minority leader, it will also be unfair for me to see somebody who has majority and what he actually needs will be like maybe 24 or 25 senators and he has up to 30. And then I will not announce it. So it doesn't matter your personal reservations. I just want to plead with my colleagues to understand that my job here is not to take individual opinions or to work on the basis of what is convenient to you, but to work on the basis of truth. So this issue of minority leader or minority whip is for now rested until you produce an alternative paper in future.
Contrary to its Friday pronouncement upholding the judgment of the Kano Governorship Election Petition Tribunal, the certified true copy of the Court of Appeal judgment, however, revealed that the appellate court had set aside the judgment of the lower tribunal. The Court of Appeal had in its Friday judgment read by the chairman of the panel, Justice More Adume, upheld the judgment of the tribunal declaring APC candidate Nasiru Gawuna as winner of the governorship elections in the state. But when the certified true copy of the judgment was released by the court on Tuesday, it was observed a number of contradictory declarations in the judgment. In the certified true copy, duly signed by the 3 justices, the appellate court went further to award 1 million naira in costs in favor of the NNPP against the APC as against its Friday pronouncement. In one instance, the appellate court declared, quote, "I will conclude by stating that the live issues in this appeal are hereby resolved in favor of the first respondent, APC, and against the appellant, Governor Abba Yusuf," but went further to contradict itself in another sentence. The court said, quote, "In the circumstances, I resolve all the issues in favor of the appellant NNPP and against the first respondent APC." The court further shot itself on the foot, declaring, therefore, "I find no merit in this appeal, which is liable to be and is hereby dismissed." But in the final line of the judgment, the court set aside the judgment of the tribunal which sacked the governor. The judgment of the tribunal in petition number EPT-KN-GOV-01-2023 between All Progressives Congress APC, delivered on the 20th day of September 2023, is hereby set aside. The CTC of the judgment says, recall that Kano State Governorship Election Petitions Tribunal on September 20 sacked the governor and declared the candidate of the All Progressives Congress APC, Nasiru Gawuna, winner of the March 18 governorship poll. Dissatisfied by the lower tribunal's decision, the governor, through his counsel, Wole Olanipekun, asked the appellate court to set aside the judgment of the tribunal. But the Court of Appeal in the unanimous ruling on Friday said the governor was not a valid candidate in the March 18 gubernatorial election. Although a presidential spokesperson, Bayo Ananuga, had denied involvement of the presidency in the case, sources, however, have stated in different platforms that the justices had initially prepared a judgment in favor of the NNPP, but forces in the presidency allegedly coerced them into changing the judgment hours before reading. The sources further said that the contradictory declarations as well as the 4-day delay in releasing the full judgment might not be unconnected with a sudden U-turn of the justices. Reactions have begun trailing this development. A human rights lawyer and activist, Femi Falana, has said that the certified true copy of the judgment of the appeal court upheld the victory of Kano State Governor Abba Yusuf, contrary to pronouncement of the judges. Mr. Falana, whose comments corroborated reports from different platforms, stated this during an interview on Arise Television.
Or even offenses of INEC or INEC officials, electoral officers. That's what the case in Kano. That one is almost scandal. And Charles, you'll be surprised if I show you the judgment. To my utter dismay, the majority judgment of the Court of Appeal in Kano upheld the appeal, set aside the judgment of the lower court in writing, and awarded cost in favor of the governor that was removed by the lower tribunal. So I'm asking myself, what's going on? Do you understand what I'm saying? Contrary to the impression that has been given out there, the judgment of the main judgment of the Court of Appeal has confirmed that the judgment of the lower court is wrong. Oh yes. And I set it aside in writing, upheld the appeal, granted all the relief sought by Governor Abba. So you ask yourself, what is going on?
Well, that's the question.
Yes.
What is going on?
So, some contradictions which the court can no longer explain, or which is likely to be taken up.
Right, well, it is being taken up today.
Recall that the court, in its Friday judgment, read by the chairman of the 3-man panel, upheld the judgment of the tribunal which declared the candidate of the All Progressives Congress, Nasiru Gawuna, as winner of the March 18 governorship election in the state. But when the certified true copy of the judgment was released by the court on Tuesday, there were a number of contradictory declarations in the judgment. In the CTC duly signed by the 3 justices, the appellate court went further to award 1 million naira cost in the favor of the NNPP and against the APC, contrary to its Friday pronouncement. Chidi Kanu has also reacted to this latest development. He says, quote, "When we say the judiciary in Nigeria is crooked, people wonder how so. Look, the Court of Appeal in Kano governorship case resolved all the issues in favor of the appellant and against the first respondent, yet it found the appeal lacking in merit and liable to be dismissed." Explain. It continued by saying that the only way to understand or explain this is that the Court of Appeal changed the judgment after they had concluded deliberations. If this does not persuade people as to how bad things are, I don't know what will. I'm hearing this evening that the court has been asking the lawyers to return the judgment for correction, but this does not fall within the ambit of slip rule. This is judicial corruption on the face